Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who've been geeking out on this channel for a while, we recently did this video right here, which was about ATF's new rules on unfinished frames and receivers and what did it mean to you, and more importantly, how were they going to enforce it. Now, that last part, how they're going to enforce it, the part that you're most interested in, actually got buried really deep in the video, and some of you may have missed it. And so I want to do a shorter, more concise video today about that topic and that topic alone. So today, let's have a really important discussion about when will the ATF require me to serialize my homemade firearm? Okay, so before we get going down the road that we're going down, proud to announce that this video is being sponsored by Legal Heat. That's right, the nation's largest educator of concealed carry classes nationwide. Legal Heat, since they began business in 2005, has educated over 200,000 people nationwide. For my Washington viewers, right here in Washington State alone, they've educated over 4,000 people. And yes, you can find a class in any one of these locations. For those of you viewing somewhere outside the state of Washington, congratulations, you're probably living freer than we are. And you can find a class in any one of your locations by visiting them at mylegalheat.com. That's mylegalheat.com. Now listen, for everyone, no matter where you are, if you find a class you like and you sign up using promo code Washington Gun Law, that is Washington Gun Law, all one word, you will receive 10% off that class. For more information, visit them at mylegalheat.com. Okay, so what we're talking about today is ATF Final Rule 2021 R-05F, better known as the new rules on frames and receivers. And amongst that was a litany of brand new rules and interpretations about unfinished frames or receivers, or what we call sometimes 80% lowers. Now, what we're going to do is in this whole rule, this big, huge word salad of a rule, there are several components, and what we're going to do is we're going to talk about one in particular today, which is what happens if you happen to have a firearm that you made out of an unserialized lower receiver, an 80% lower, which at the time you did it there was absolutely nothing unlawful about it in any way, shape, or form. What does this rule mean to you moving forward if you have firearms like that? Okay. First of all, this new rule actually comes up with a much more euphemistic term, which is personally made firearm or privately made firearm. Now, that is much better than what the mainstream media calls it, which is ghost guns. For my Washington folks, we call them untraceable firearms, which again is still a far more euphemistic term than ghost gun. But what is the definition under this new federal rule of a privately made firearm? It's defined as follows. A PMF is a firearm including a frame or receiver completed, assembled, or otherwise produced by a person other than a licensed manufacturer and without a serial number placed by a licensed manufacturer at the time the firearm was produced. Okay, so a PMF is a firearm which was produced by a non-licensed manufacturer. That means some average citizen that did not have a serial number affixed to it at the time that it was converted into a firearm, okay? This is your traditional build out from an 80% lower or something like that. What we need to talk about is what do you have to do if you have firearms of this nature? Now, let's first talk about what this rule does, and then let's talk about what this rule doesn't do as it relates to these types of firearms, okay? We're talking about PMFs, privately made or personally made firearms. For my Washington folks, we call them untraceable firearms. And by the way, for my Washington folks, they know that we've been dealing with this issue for a number of years. In Washington State, we've had this terminology. We've had laws that regulated these for some time, okay? And we have even more stricter regulations which went into effect this year. Federal law is beginning to catch up with Washington law, and for those of you nationwide, that's not a good sign, by the way. Okay, so here's what the rule does, okay? The rule for the first time ever defines unfinished frame or receiver and also defines privately or personally made firearms. So these are all new definitions that we've never had before. Now, in addition to that, It also broadens the term of those who are engaged in the business of gunsmithing and things like that, and that is to allow more people the ability to engrave firearms. So yes, they are prepping for far more engraving, but we're going to get to that in a second, okay? That it also, and this is important, it regulates what FFLs have to do with privately made firearms that are in their inventory or that come into their inventory. And that's going to be the rub here right again. And then it sets some certain dates for FFLs about what they have to do with these firearms and when they have to do it by. That's what the rule does, okay? And we'll get into the details in a second here. Now, here's what the rule does not do, okay? It does not prohibit you from making a privately made firearm moving forward. You can still make a privately made firearm. What's going to be different is your 80% lower is now going to be an 83% lower because it's going to come with a serial number. And yeah, you're going to have to go through the 4473 and the background check and whatever else your state makes you do in order to purchase a firearm, because this is going to be treated as a completed frame or receiver. Therefore, you are in fact going to go through all the hoops you need to purchase a firearm. So that's one of the things that you understand. It does not preclude you from making PMFs. It does change how you make them and what you use to make them, okay? It does not, and this is important, it does not mandate any individual right now to go out and mark any PMF. If you have a privately made firearm in your possession now, milled out from an 80% lower or some other type of lower frame or receiver, which was unfinished, you purchased it, it was shipped directly to you, you do not need to mark it. As this rule sits right now, this date, there is no requirement that you mark any of these firearms. And then this is important, okay? This rule does not apply to any firearm that was manufactured or made before October 22nd, 1968. Now, for my Washington residents, we know there's a major loophole in our law, which is a untraceable firearm is any firearm that doesn't have a serial number, which was manufactured on or after July 1st of 2019. But now federal law is going to be able to take Washington residents all the way back to 1968. Okay, so this is how it works. If you have a privately made firearm, you do not need to mark it. Right now, as this rule exists, there will never be a need to mark it unless it ends up in the inventory of an FFL. The rule in the comment section by ATF specifically states, the final rule amends the regulations to require all FFLs to identify and mark any PMF they take into their inventory. Okay, now, how does a firearm end up in their inventory? There are multiple ways that a firearm can end up in an FFL's inventory. You could sell it back to them. It could be used in the sense of you're making a transfer or something like that, and the FFL is hanging on to it. Obviously, FFLs can have some in their inventory right now because perhaps they ordered them from a retailer or something to that effect, all right? The thing is once that firearm is in their inventory, it has to be logged into a book, and therefore, if this is defined as an unfinished frame or receiver, which is in a position where with a little bit of craftsmanship, it can be turned into a fully functional frame or receiver, they're going to have to mark this. They're going to have to serialize it. If they cannot do that, they cannot accept it into inventory. Here's the other way that firearms end up in inventory. You take it to a gunsmith at an FFL for some work, and it needs to stay overnight. The minute that firearm is staying overnight, or any extended period of time, it is going into FFL inventory. They have no choice in the matter. They have to book it into the inventory. The rule makes it very clear that same day adjustment, same day work, drop it off in the morning, pick it up in the afternoon, even if it's an untraceable or otherwise unmarked PMF, okay, there is no requirement for the FFL to mark it if it never enters their inventory. The comments by the ATF specifically stated, notably, licensees are not required to mark PMFs received for same-day adjustment or repair and return to the person from whom it was received. So I hope that answers at least one of the questions that most of you are worried about. If you have a homemade firearm, a privately made, personally made firearm, for my Washington residents, we call them an untraceable firearm. If you have any one of those, are you required to go out and get it marked right now? No. Are you going to be required to go out and get it marked under this particular rule? The answer is no. However, If that firearm, for any reason, ends up in the inventory of an FFL, the FFL is mandated by federal law to mark it. Now, there will be other videos that we're going to do for FFLs about how do you mark it, what's the requirements of it, and so forth. But for you, the lawful and responsible private gun owner out there who may have untraceable or privately made homemade firearms, the way to avoid them from becoming marked, if that's what you're trying to avoid, is that they can never go into FFL inventory. Okay, and then finally, a real important note for my FFLs. What is the timeline? Any privately made firearm in your inventory prior to the enactment of this rule, August 26th of 2022, you have 60 days to get it marked. However, any firearm that you receive into your inventory, which is untraceable, privately made firearm after the enactment of the date, August 26th, you only have 7 days to have that marked. We'll be doing more videos about the marking requirements, who can do it, what does it need to be done with, how do you do it, where do you do it, all of those details we will do in separate videos. In the meantime, some of you may have more questions about this, and if you do, remember you can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.